Welcome to While We Were Distracted, the podcast where we explore topics that often get overshadowed in the rush of daily life.
Okay, so let's unpack something that I think is probably haunting your LinkedIn feed right about now.
Oh, the whole AI taking over everything anxiety.
Right, exactly. We spend so much time worrying about artificial intelligence stealing our jobs. Like, that is the headline we see every single day, the robot coming for your paycheck.
It really is the anxiety of the decade, for sure.
But today's deep dive is actually flipping that narrative in a way that is honestly kind of wild. Because we aren't talking about an AI doing the job.
No, we are definitely not.
We are talking about an AI breaking the law to keep people from getting the job in the first place.
And not just in a, minor computer glitch kind of way.
Right.
We are talking about a direct violation of federal civil rights law.
It is a story that sounds like science fiction, but it is happening right now in Virginia. We are looking at a stack of documents regarding a settlement involving a company called, wait for it, Elegant Enterprise-Wide Solutions, Inc.,
which is quite the corporate name.
It really is quite the name. So they are an IT professional service provider based in Virginia. And just a couple of days ago, on February 25th, 2026, they settled with the Department of Justice.
A major settlement,
yeah. And the issue, they let an AI tool write their help-wanted ads. And let's just say the AI had some very specific and very illegal preferences.
This is a massive moment. I mean, if we connect this to the bigger picture for you listening, this isn't just a story about a rogue algorithm.
Right.
This is a precedent-setting case about liability. We are looking at an official press release from the DOJ's Civil Rights Division that answers a question we have all been asking. Who is responsible when an algorithm discriminates?
Exactly, because usually if a human recruiter says, I don't want to hire people from this specific country,
that person gets fired immediately.
Right. They get fired and the company gets sued. But what happens when it is a piece of code doing the screening?
That is exactly what we are going to explore today. We are analyzing the official release regarding a settlement under the Immigration and Nationality Act, or the INA.
Okay, so let's start with the glitch itself. What actually happened at Elegant Enterprise-Wide Solutions?
So here is the situation. You have this IT company, right? And like every other company in 2026, they are trying to streamline things.
To save a little time, save some money.
Exactly. So they use an AI tool to generate their job advertisements. You punch in the requirements, and the AI spits out a nice, professional-looking ad to post on the job boards.
Pretty standard stuff. I think everyone is doing that right now.
In theory, yes.
Yeah.
It is supposed to just save time.
But here is where it gets really interesting. And by interesting, I mean legally disastrous. The AI explicitly included language in these ads that restricted the jobs to applicants with very specific visa statuses.
And it didn't just imply it?
No, it wrote it right out.
And this is where the details really matter. The AI wasn't just looking for qualified candidates. It was looking for specific immigration classifications. According to the DOJ, the ads restricted consideration to applicants with H-1B visas, OPT, or H-4 visas.
Okay, so alphabet soup time. For those of us who aren't immigration lawyers, can you break those down? What was the AI actually asking for?
Sure. So H-1B is the big one most people know. That is for specialty occupations, usually requiring high levels of education, often in tech or engineering.
Got it.
Then you have OPT, which stands for Optional Practical Training.
Okay.
That is typically for international students who have finished their degrees in the U.S. and are allowed to work for a certain period, usually 12 to 36 months, just to get training in their field.
Right, so recent grads.
Exactly. And finally, H-4. Those are visas for the dependents, like spouses or children of H-1B holders. And some H-4 holders have authorization to work.
So the AI creates an ad saying, we want people with these specific visas. Why is that a problem? I mean, is it inherently wrong to want someone with a visa?
It is a problem because of who it actively excludes. The Immigration and Nationality Act has a very clear provision regarding citizenship status discrimination. By saying only these visa holders can apply, the AI was effectively and illegally telling U.S. citizens, U.S. nationals, refugees, and recent permanent residents, do not apply. You are not welcome here.
That is the irony that just completely kills me. You have an American company based in Virginia, using a robot to exclude American workers?
It is a profound irony. And it really raises the question of why the AI did that, though the source text doesn't speculate on the black box mechanics of it.
Right, we don't know the exact prompt.
We don't. But the outcome was undeniable. It created a preferential lane for temporary visa holders and put up a massive brick wall for U.S. workers. And under the law, you simply cannot discriminate against U.S. workers in favor of those with employment visas.
So Elegant Enterprise-Wide Solutions, Inc. posts these ads, the DOJ sees them, and now we have to talk about the defense.
Yes, the defense.
Because I feel like the first instinct of any CEO in this situation would be to point at the computer monitor and say, it wasn't me, the AI went rogue, I didn't type that.
It is the modern equivalent of the dog ate my homework, isn't it? The chatbot wrote my lawsuit.
That is exactly what it is. I am just a victim of technology. But does that defense actually fly?
According to this settlement, absolutely not. And this is where we really need to look at the statement from Assistant Attorney General Harmeet K. Dillon of the Civil Rights Division.
We have a direct quote from the press release here, and honestly, it is pretty spicy for a government document.
It is uncommonly direct. Dillon said, and I'm quoting here, "It is unconscionable for companies to illegally exclude U.S. workers when recruiting and hiring."
Unconscionable. That is a really strong word for a press release.
It is, but the next sentence is the one that really matters for everyone listening who uses AI in their office.
Lay it on us.
Dillon went on to say, "This Department of Justice will not tolerate discriminating against U.S. workers, no matter who or what drafts a job advertisement."
Who or what?
That is the key phrasing right there.
That is the line that stuck with me, too. It explicitly names the what.
What fascinates me here is that the DOJ is effectively closing the liability loophole before it can fully open. They are clarifying that the legal standard remains exactly the same.
So the tool doesn't matter.
It does not matter at all if the discriminatory test was typed by a fatigued HR manager, a biased recruiter, or a bleeding-edge generative AI tool. The company is the entity responsible for the output, period.
So you can't outsource your liability to a server farm.
Precisely. If you use a tool, you own the results of that tool. Think of it like this. If you use a hammer and break a window, you can't blame the hammer. If you use an AI and break a silver light slot, you can't blame the code.
That is a serious wake-up call. I think a lot of people view AI as this sort of magic box. You throw a prompt in, you get a result out, and because a computer made it, we assume it is neutral, or at least legally safe.
We assume it is objective. But as this case clearly proves, AI can hallucinate discriminatory preferences just as easily as it can hallucinate a fake historical fact. Or it can just blindly replicate biases it found in its training data. We don't know exactly how this specific tool came to this conclusion, but the result was a direct violation of federal law.
So, Elegant Enterprise-Wide Solutions, Inc. is on the hook. But this isn't just about one company in Virginia, is it?
No, and that is crucial to understand. If we zoom out and look at the broader context, this is actually the 8th settlement of its kind.
The 8th. So this is a real trend.
It is absolutely a pattern. The DOJ relaunched something called the Protecting U.S. Workers Initiative back in 2025.
Okay, what does that initiative do exactly?
It is specifically designed to enforce the INA's prohibition on citizenship status discrimination. They are actively out there hunting for companies that favor employment visa holders over U.S. workers.
And clearly they are finding them.
They are. And now that AI is entering the mix, the speed at which these violations can happen is dramatically increasing.
Oh, wow. I didn't even think about the speed.
Right. Imagine how many ads an AI can generate in an hour versus a human HR person. If your prompt is bad or the model is biased, you could scale up your discrimination instantly across thousands of job postings.
That is terrifying. So what happens to the company now? They got caught, they settled. Did they just get a slap on the wrist?
It is quite a bit more than a slap, though the specific dollar amount wasn't in the excerpts we reviewed. But the settlement terms are significant. First, there are civil penalties.
Okay.
The press release states the department will continue to seek the maximum penalty permitted by law.
Maximum penalty. That does not sound cheap.
No, it doesn't. And then there is the back pay.
Oh, right, because if you didn't get the job or didn't even bother to apply because of the discriminatory ad, you lost out on income?
Exactly. The settlement involves awards of back pay where warranted. Now, identifying those specific victims can be tricky, but the mechanism is there to compensate people who were illegally excluded.
What about actually fixing the internal problem?
That is the third pillar of the settlement, mandatory training. The company has to conduct comprehensive training for its relevant staff and recruiters.
There is a certain irony there in mandated human training because the robot messed up.
Well, the humans have to know how to properly supervise the robot, right? They can't just set it and forget it. They also have to sign a cease and desist.
Meaning they have to stop the behavior entirely.
They are under a strict order to stop restricting job opportunities based on citizenship status without a lawful reason.
Which actually brings up a good point. There are lawful reasons sometimes, right?
There can be, yes, in very specific national security contexts or specific regulatory environments dealing with classified tech.
Right, clearance stuff.
Exactly. But generally speaking, for a standard IT professional service provider, no. You cannot say H-1B holders only just because you prefer them.
Okay, so let's say I am listening to this deep dive right now, and I'm realizing, wait a minute, I saw an ad exactly like that last week on a job board. Or maybe I felt like it was filtered out of a process because of my status. Is there anything I can actually do? Or is this just something the DOJ handles internally at a high level?
No, there is a direct line for this. The DOJ takes this seriously enough that they set up a dedicated hotline.
Oh, really? An actual phone number?
Yes. If you feel you have been discriminated against in this manner, there's a number you can call. It is 1-800-255-7688.
Okay, let me repeat that for the listeners. 1-800-255-7688.
That is the worker hotline for the Immigrant and Employee Rights section. And interestingly enough, there's actually a number for employers, too.
Really?
Yeah, if they are unsure about the law and want to avoid being the next DOJ headline, they can call and get guidance.
That is probably a very good number to call before you let ChatGPT write your entire hiring strategy for the year.
I would highly, highly recommend it.
So, bringing it all together, what does this all mean for us? We have covered the glitch itself, the legal framework, and the penalty. But when you step back and look at this snapshot from February 2026, what is the big takeaway?
I think the big aha moment here is shattering the illusion of automation as a safety net.
Tell me more about that.
Well, we often view AI as a solution, a way to remove human error and make things more efficient. But in this case, the AI didn't remove error at all. It automated liability.
It automated liability. That is a truly terrifying phrase.
It should be. The AI replicated or maybe hallucinated discriminatory preferences and then rapidly published them to the world, creating a massive legal headache.
Right, so the ultimate takeaway is trust but verify.
Trust, but audit. Relentlessly. As we rely more and more on automation in 2026, the human duty to check that work hasn't gone away.
If anything, it seems more important.
The stakes are infinitely higher because the scale is bigger. You cannot just click generate and walk away to get a coffee.
It really reinforces that idea that the human is the ultimate firewall. The software doesn't know civil rights law. It doesn't have a conscience. It literally just predicts the next word in a sequence.
Exactly. And the law does not care how the discrimination happened, only that it did.
Well, this has definitely made me look at those suggested text pop-ups on my screen a little differently.
As it should. Every prompt is a potential liability if you aren't paying attention.
Before we wrap up today, I want to leave you with a thought. We just spent this time talking about an AI accidentally breaking the Immigration and Nationality Act. It was public, it was in a job ad, and the company got caught.
Right. It was out there for the world to see.
But here is the question for you to mull over. If an AI tool can accidentally break civil rights laws based purely on how it was prompted or trained, what other internal policies or laws might your office software be quietly violating right now while no one is looking?
That is exactly the question that should keep compliance officers up at night.
Think about that the next time you ask a chatbot to draft a quick contract.
Yeah.
Thanks for diving in with us today.
Always a pleasure.
Don't forget to like and subscribe for the next episode on While We Were Distracted.